Today, our topic for discussion is mensrea. First of all, we will learn the basic of mensrea. What does it mean? So, basically, mensrea means to have a guilty mind. Mensrea, or the mental element of crime, is very important part of criminal law in India as well as in other countries. Most laws in India contain the element of guilty mind so as to make an act by a person criminally liable for punishment. That is what the basic of, you can say, mens rea is. Okay. If we come to a detailed description of mens rea, then mens rea means an intention to do a forbidden act. We already know what does a forbidden act means. That is not legal in the case of you can say law. It is a crime in a specific country, and then the intention to do that crime is known as mens rea. The term mens rea is not defined in the Indian Penal Code. It is defined as the mental element necessary to constitute criminal liability. If you will find mens rea in the IPC, then nowhere you are going to find it, because it is defined as a mental element which is necessary to constitute a criminal liability. Every criminal must have something in their mind with which he or she has committed a crime. According to Shamsul Huda, an eminent jurist, the very cornerstone of criminal jurisprudence is the mens rea. It is expressed in Latin maxim actus non fecit reum nisi mens sit rea as a fundamental principle for penal liability. The maxim means the act itself does not constitute guilt unless done with a guilty mind. In easy words, we can say that any act which has been done without a guilty mind, without having an intention to doing it, and which has caused harm is not a crime. But if someone is doing something by knowing that if I will do it, then the person will suffer from injuries or sustain injuries, then he has a guilty mind, and the act which has been constituted makes him guilty. So the maxim means the act itself does not constitute guilt unless done with a guilty mind. Now, a person to be held guilty of a crime, it is necessary that he had an intention to do it. Similarly, a person to be held guilty of either being theft or something else, it should be established that he had an intention to steal. There are a lot of examples around us. We have malls, we have shopping complexes where you're going and you have to pick up something, some items, then you have to go to the cart, right? Then you have to pay bills, and then you will be able to take it out. If someone is lifting it up by the intention of purchasing it, but at the cash counter, maybe he or she forgot to pay the bill of that item, and then he was moving outside the gate, and if he get caught, it doesn't mean that he was going to steal it. So no act of the person was punishable in the absence of mens rea. If there is no mens rea, no person can be punished because there is no intention to do a crime. If we talk about the origin and development of mens rea, it was in 12th century. Mens rea was not an element of crime. The wrongdoers used to get punished regardless the fact that whether the act done was intentional or not. In 12th century, we were not caring about the intention of the person. If something has been done wrong, then the wrongdoer will be punished. So the concept of mens rea was first introduced in the 17th century, along with the Latin maxim actus reus non fecit reum nisi mens sit rea that I discussed in last slide. There can be no crime without a guilty mind. This maxim cleared the conflict that a crime can only be said to be constituted where the action was done in accordance with a guilty intention. There were many cases in history. We can cite those cases like R versus Prince in 1875, or be it Queen versus Tolson in 1889. So there are more cases. If you uh, do a bit of research about it, you will get to know. So, what is the essentials of mensrea? Before getting to the exceptions, I would like to discuss the essentials of mensrea. So, mensrea is constructed from a person's thought process, their motive and intention. And motive and intention are two separate ideas. Motive is the reason behind the act, whereas intention is a person's state of mind and willingness to break the law. There are two different things. I will repeat that motive is the reason behind the act. Like if I am doing something, if if I have to pick up a glass that is kept on the table, I will be walking towards this. My motive is what? To pick up that glass. That is why I am moving towards it. But intention, if my intention is to take that glass and you know make it free fall from my hand to the floor, so it is my intention. So it is my willingness that I will go pick up the glass and I will throw it, or I will make it free fall. So these are two different things. If we talk about intention, it is the state of mind of the person doing the crime. It can be proved when the defendant can foresee virtually that the consequences of the action of the person is going to kill or cause grievous injury or any other prohibited harm to them. That is what intention means. If we talk about motive, a motive is criminal law. A motive in criminal law is the cause that moves people to induce into a certain action. Motive is not a basic element of crime, but it is mostly looked into while investigating a criminal case. Motive is the reason of any act, Hence, even if motive was good but the act was wrong, then criminal liability may arise. If you are thinking that if I am going to do this, he will definitely be benefited, but it is a crime, then you are doing a crime. Even if you are having a good motive behind that, you will be having a criminal liability. So that if we talk about other factors which constitute or which play a major role in you can say in proving a criminal liability, or in experiencing that what up to what extent a person is guilty, we talk about knowledge. The word knowledge or knowingly is used in certain places in IPC to denote mens rea. It can be seen from two sides. Firstly, a person had knowledge and act in a wrongful manner, and secondly, they had knowledge about the bad consequences and chose not to act, hence resulting in a wrongful act. Both can be understood as a part of mens rea and are punishable. Then we have negligence. It cannot be used as synonym for mens rea, but while looking for guilty intent in any criminal case, this aspect is also covered. Negligence is a lack of attention or due care that a reasonable or prudent person may have while performing any task. For a negligent act to turn into criminal negligence, its degree, it shall be high enough to cause criminal liability. If someone is negligent towards something, he may be convicted for a criminal liability. Then the last one would be voluntarily. This word is used in the code to show that the person doing an act had the knowledge of what they are doing and had full control of their actions. Voluntarily can be used to show intention as well. It is used only because it has more extending meaning than intentionally. If someone is doing a self defense, if we talk about self defense, if someone is doing self defense and he or she is carrying a knife, voluntarily he is knowing or she is knowing that if I am using the knife on the chest region or in the stomach area, that at what area she has or he has knowledge that if I am using the knife on this particular area, then the person is going to die. Certainly, he's going to die. And then again, you are using the knife over there. Then it is not a good motive. I would not say good motive. Your intention was not good. If you just want to protect yourself and hand over the criminal to the police, you should have used knife somewhere else on the body. So these were some of the essentials of mensrea. Now come back to our slide, exceptions of mensrea. And according to Wright J, the mensrea is an essential ingredient in every offense except in 3 cases. What are these 3 cases? The first one is cases which are not criminal but are prohibited in the public interest under penalty. So the first ingredient in every offense in which mensrea is not essential ingredient is cases which are not criminal but are prohibited in the public interest under penalty. Second one is public nuisance. And the third is cases which are in the form of criminal cases but actually are for enforcing a civil right. Therefore, there can be no crime without an evil mind, and hence the essence of an offense is mens rea. What does a crime constitute of? If we talk about its actus reus plus mens rea, which makes a crime. If any of these are absent, you can't say there is a crime. So, these 3 exceptions and then actus reus plus mens rea constitutes a crime. Now, if we look about the model penal code, then the model penal code recognizes 4 different levels of mens rea, which is purpose, same as intent, knowledge, recklessness, and negligence. We have already talked about this as the essentials. The key feature added by the model penal code system is that for any criminal statute, unless the statute specifically states otherwise, the defendant must commit all elements of the crime with a mental state of recklessness or greater, that is, recklessness, knowledge of purpose. What does this purpose mean? We are talking about purpose, recklessness. So, purpose is a person acts purposefully, intentionally, if he acts with the intent that his action causes a certain result, which we have already discussed as the essentials. So, in other words, the defendant undertakes his action either intending for or hoping that a certain result will follow. Then we have knowledge. A person acts knowingly if he is aware that his conduct will result in certain consequences. In other words, a person acts knowingly if he is aware that it is practically certain that his conduct will cause a specific result. In this knowledge, the person is knowing that if I am going to do this, certainly this will happen. Then what are the objective? The objective of mens rea. The objective of law is always to punish a person with a guilty mind. There is no doubt in that. But it does not want to put behind bars an innocent person who may have had the misfortune of being involved in an incident, an event, which he did not have the intention of participating in. We talk about a crime which has been committed by a crowd, and if someone is over there in the crowd but he has no intention, then he should not be punished. The existence of the mental element or guilty mind of mens rea at the time of commission of the actus reus or the act alone will make the act an offense, which I have already showed the slide with the actus reus plus mens rea constitutes what? A crime. So, overt or outward act, or the actus reus, has also an essential ingredient of crime. The element of mens rea as an essential ingredient of a crime is also approved by the growing modern philosophy. The object is that punishment should fit the offender and not merely the offense. Now, moving towards last slide, the mens rea that is described in the IPC. So, under the 10, guilt in respect of almost all the offenses is fastened either on the ground of intention or knowledge or reason to believe. Though the word mens rea as such is nowhere found in the IPC, its essence is reflected in almost all the provisions of the code. For framing a charge for an offense under the IPC, the traditional rule of existence of mens rea is to be followed. Chapter 4 of the OD deals with general exceptions wherein acts which otherwise could constitute offenses cease to be so under certain circumstances. However, this general or traditional rule that mens rea is an essential element in IPC offenses is not without its exceptions. Like all other statutes, the deciding factor on whether mens rea is required or not depends on the language of statute and the intention of the legislature as gathered from the statute. That is all from my side for the mens rea. Have a good day, and for more updated topics and detailed studies, please be with S&M Partners. Thank you so much.